The leak of a draft Supreme Court opinion.
The Supreme Court.
The court that dark money built.
Breaking news at the Supreme Court.
The landmark Roe v. Wade case.
A woman's constitutional right to an abortion.
My body, my choice.
And Leonard Leo, who really is responsible for helping Trump fill the Supreme Court.
A Supreme Court decision with dramatic consequences. The justices ruling 5-4.
You look at the decisions like Shelby County that attacks voting rights, and then you look at the dark money cases like Citizens United. It's not just us.
The court is not in order. This is Senator Sheldon Whitehouse, and welcome to Making the Case. I have the great joy and privilege of welcoming to the podcast Jamie Raskin, the congressman from Maryland, who, if things go right in the next election, will likely be the chairman of the House Judiciary Committee. And on the chance that things go right for us over in the Senate, I would likely be the chairman of the Senate Judiciary Committee, which gives us the opportunity to do a lot of great work together. Thank you, Jamie, for being here.
I'm delighted to be with you, and if and when we do win next year, to be your counterpart in the House.
We'll have productive work.
We've got a lot of work to do.
So one of the issues we've been doing a lot of work on has been the Supreme Court. And the notable recent news out of the Supreme Court has been Justice Ketanji Brown Jackson's dissents. We've had sharp dissents from Justice Kagan and Justice Sotomayor before, but Justice Jackson has gone a slightly different path, which is not just to critique the analysis of the majority, but to try to put it into context of other decisions, to compare and contrast how standing is treated when it's a corporation involved versus when it's a criminal defendant involved, how the case at hand stands in line with other cases that have been treated differently when the party is different. What have you noticed about that?
But yes, I've noticed the exact same thing. I would put it in two different categories. One is Justice Jackson creating a contrast between the way doctrines are deployed when it comes to a right-wing agenda versus the way they're applied for everybody else. She first started pointing that out with respect to equal protection. The Equal Protection Clause basically doesn't work for African Americans and racial minorities and women anymore. It's been completely hollowed out. The Supreme Court has said you've got to show that the purpose is to discriminate against a particular group. But if you've got, a conservative white organization that's suing to bring down majority black or majority Hispanic congressional districts, never is the question asked whether there's a purpose to discriminate against white people. It's simply enough to say, oh, there's squiggly lines on a map, therefore that should be construed to constitute an equal protection violation against white people, even though there are bizarrely drawn lines all over the map for majority white districts. But those are never construed to create a purpose to discriminate against racial minorities. So she always points out how the doctrines are deployed in such a way as to advance a right-wing agenda. The other thing that's going on is she's not only demonstrating the doctrinal incoherence and infidelity of the conservative majority, but she's also sending a message to all of America about the danger that we are in from people who don't respect the rule of law and don't respect democracy and voting rights for the majority. So I would liken her very much to Justice Scalia on the other side. Scalia was often talking to corporations or the Republican Party about what they needed to do in order to deal with progressive constitutional doctrines that he didn't like. And what she's saying is there are people on the Supreme Court right now who are ravaging American constitutional democracy.
The interesting thing about it, in addition to what she has actually done, is what the reaction has been. It verges on real right-wing panic out of particularly the court capture enterprise that has stacked the court with these 6 far-right Leonard Leo / Federalist Society / creepy polluter billionaire appointees. And it strikes me that there's more to be discussed if she really wants to keep going that way. I mean, I think it's within her power to note the practice at the court of how often they follow the recommendation of these secretly funded flotillas of right-wing amici. They're batting 1,000 with the Supreme Court. She could start tracing doctrines like the Major Questions Doctrine back to fossil fuel-funded think tanks with the whole history of how those phony doctrines were grown and reverse engineered to produce results. So,
well, while she's also pointing out that, of course, the Major Questions Doctrine is nothing that interests the right wing on the Supreme Court today, when everything that the Trump administration has been doing is major revolutionizing of federal law and the Constitution. I mean, just go to the executive order denying people birthright citizenship. If that's not a major new departure in public policy, I don't know what is, but it would never occur to Alito and Thomas to say, oh, well, you can't just reinterpret decades and decades of statutory and constitutional interpretation to rope off citizenship from people who've traditionally had it, because that's a major question, and that's got to be left up to Congress and or the people. So, look, they don't mind a faux populist Supreme Court justice like Scalia, who goes out and makes lectures and speeches. But I think you're right. They're very nervous about a populist democratic justice with a small d there, who's speaking to the people about the threat to the rule of law from within the Supreme Court.
Because in point of fact, their court capture operation, while somewhat covert, certainly left plenty of footprints and fingerprints for an alert justice to look into. So you, with any luck and the goodwill of the voters, will be the chairman of the House Judiciary Committee in the next Congress, which will give you oversight over the courts. And one character who is at this point headed for the courts is Emil Bove, who manages to have embroiled himself in no less than 3 prosecutorial misconduct episodes in his 6 months in the Justice Department. I suspect that his behavior is not going to get any better after he's confirmed to the Third Circuit Court of Appeals. What are the tools that the Judiciary Committee of the House has to look into misconduct by judges should his behavior continue?
Well, we've got all the powers of oversight to conduct hearings, to demand documents. We'll have the subpoena power to get the information we need. Now, of course, since we're dealing with a lawless administration that doesn't respect the independence of the United States Congress and our oversight function, we're going to have to fight in court to make that real. In the last administration, you'll recall, President Trump just sent out a blanket order to stop complying with all subpoenas, not just stuff investigating him for his various criminal corruption scandals, but things just dealing with discovery about the environment, big oil, regulatory compliance, whatever it might be. So we're going to have to fight for it, but we do have that power. And we will exercise it, as I hope the voters will give us the power to do.
One of the 3 prosecutorial misconduct episodes that Bove was involved in was the illegal deportation efforts of the Trump administration that led to a federal judge deciding that there was probable cause to find that contempt of court had taken place, and that justified a hearing. And of course, in a court hearing, you have to testify. You got to testify under oath. If you lie or fail to answer questions, there are immediate and real consequences and so forth. So Bove was neck deep in that whole scheme. And if that contempt hearing had gone forward, it would have built a record about his misconduct in that particular episode. But 2 Trump judges on the D.C. Court of Appeals, Judge Rao and Judge Katsas, over the objection of Judge Pillard, dropped an administrative stay in place that has prevented that hearing from going forward while Bove's nomination goes through the Senate. It looks very much to me like those are coordinated effort that somebody got those two judges to drop the administrative stay over the contempt proceedings so they could shove Bove through without that record having been developed of his misconduct. What do you think the chances are of that? And if you're familiar with what an administrative stay is, how weird is it that administrative stay has lasted in place for 3 months?
Very odd. And we certainly will be interested in patterns of executive branch interference with the courts. I mean, look how extreme the situation is right now, Senator Whitehouse. In the old days, the executive branch respected the independence of the law enforcement function in the Department of Justice. Donald Trump has completely taken over the Department of Justice. Everybody there is his former lawyer, people who've sworn political fealty to him, people who say their job is to implement the will of Donald Trump. And that seems to be all they're doing. But it's not enough. They want to spill over and then use those lawyers full time to advance Trump's very narrow personal and partisan political agenda with the judges and to get them to do the will of Donald Trump. That's just a hallmark of authoritarianism when the president's trying to control judicial decision-making. And that's clearly what they want to do and where they're headed. We are going to have to use whatever power we have here to stand up for the independence of the judicial function and the judges. And that means protecting their security. It means protecting their salaries and protecting them from direct political interference. And, I'm not sure what's going on over here in the Senate, but on the House side, we've got MAGA Republicans calling for the impeachment of judges just because they've ruled in a way that Donald Trump doesn't approve of. So you take Judge Boasberg, for example, who said, turn the airplanes around. We have due process in America, right? And they call him a radical left rogue judge. There are posters up saying wanted and calling for the impeachment of him and other judges. The guy was a Bush appointee when he first got on the bench. He was Justice Kavanaugh's roommate at Yale Law School and is considered a pillar of the conservative establishment. My colleagues never say what they think is wrong with his opinion, what's wrong with his analysis. It's just taken for granted that he decided in a way that Trump doesn't like, and therefore he should be impeached. And they're calling for impeachment of all these judges because we've got 196 temporary restraining orders and preliminary injunctions now across the country at the district court level. The district bench, Democrats, Republicans, everybody else is standing up for the rule of law, and that's what they can't handle.
Well, here's a predicament that the MAGA Department of Justice is going to have related to judicial security, which is that the Marshal Service that provides security for judges is also, at least in the first instance, supposed to investigate threats against judges. Very often they'll hand complex stuff off to the FBI, but they have an investigative responsibility to look at threats, which includes the investigative responsibility to look at orchestrated threats. But Attorney General Bondi and the MAGA Department of Justice, the last thing that they're going to want to do are to approve orchestration investigations that look into who is behind all of these threats to our judges' security, because it leads straight to MAGA.
I mean, here's another person we cannot count on in the Department of Justice, Ed Martin, who was their acting United States attorney for the District of Columbia, who was a lawyer for the January 6 criminal defendants. For a whole bunch of them, he lionized them, he praised them, he glorified them in every conceivable way. And while he was U.S. attorney, he was sworn in, he actually got charges dismissed against some of them, and of course was a huge cheerleader and enabler for the pardons of the January 6 criminal defendants. And one of the January 6th convicted defendants has actually now gone to work for him on the anti-weaponization task force. So right now, you've got a Department of Justice which is completely in the camp of the election deniers, the January 6 deniers, and the conspiracy theorists.
And while Mr. Martin was at it as acting U.S. attorney, he also tried to cook up a fake criminal investigation as a pretext to try to seize appropriated, obligated, and disbursed federal funding, and broke innumerable Department of Justice rules on the way there, got told there was no criminal case by the criminal chief, so he drove her out, Everybody else in the U.S. Attorney's Office refused to sign his pleading because there was no real criminal case. So he went forward himself, which almost never happens as a U.S. attorney. I was one. And then he got shot down by the magistrate judge who said there's no case here, which again never happens because a real Department of Justice goes out of its way to make sure that it's winning these cases before magistrates and not putting them in a position with a poorly supported affidavit or petition. And he was behind that whole scheme. So these people, they run wild in violation of really basic prosecutor principles. And back to our friend Emil Bove, he was neck deep in that scheme. That's one of the other prosecutorial misconduct episodes. One of the things that you have to worry about that we don't have to worry about in the Senate is gerrymanders.
Yes.
And you're seeing new activity on gerrymanders in House districts. What are you seeing over there?
Sheldon, this is the whole ballgame. The Texas legislature was called back in for an extraordinary session this week, a special session, putatively to deal with the flooding crisis, which tragically cost hundreds of people their lives and their livelihoods. And yet the very first thing they did, and that they're working on this week, is to redraw the already gerrymandered maps in Texas to squeeze out, as Donald Trump put it, 5 more U.S. House seats for the Republicans. In other words, they want to move from a terrible gerrymander in Texas to an extreme gerrymander. And again, a right-wing Supreme Court has upheld this extraordinary process of a mid-decennial redistricting before, and it looks like the Republicans now want to make this the pattern. In other words, you do your normal gerrymander at the 10-year mark, and then you see if you've got surplus votes that could be lopped off and shared in another district in order to further eliminate any possibility of Democratic representation. And so if they get away with it in Texas, then they say they're going to Missouri, they're going to Ohio. I have a colleague who told me he heard that Governor DeSantis wants to do the same thing in Florida because he certainly doesn't want his competitor, the governor of Texas, to get ahead of him in this. But what they're looking at is squeezing out every possible Republican seat that's mathematically possible. And this is one of the things that they told the Republicans in getting them to vote for the horrific, monstrous bill that they just passed, throwing 17 million people off of their Medicaid health care. Don't worry about it. We're going to be able to save a lot of seats and add more seats, add to the majority by gerrymandering, and we'll get everybody the money that they need. So you'll be okay, because a lot of the Republicans were very nervous about voting for such a terrible, monstrous bill. And yet this is their safety valve plan. They're going to gerrymander their way back into victory. There's no way that they can win a majority having just assaulted the health care of the people, taken away SNAP food benefits from the people. It just wouldn't happen. Everything for them is just trickery and strategic mischief, and that's what they're up to now.
The general process of gerrymander has been to try to squeeze out as many, let's say 55% Republican districts as you possibly can, and then have the remaining districts be 80 and 90% Democrat districts, basically corralling Democrats into just a few districts so you get as many Republican districts as possible. But if you want to go from where you are in an already gerrymandered state and try to spread out to even more districts, it's hard to make that work at 55%. You now have to start dropping your majority number in your existing districts to maybe 54, 53, 52%.
Yes.
Which creates the risk that in a good, solid, anti-Trump, pro-democracy, anti-creepy billionaire wave election, they could lose a lot for this crooked gambit.
It's true, unless they add to their extreme gerrymander voter suppression tactics that make it difficult for Democrats to vote. I was down in Texas recently with my friend Greg Kassar and Lloyd Doggett. I met with a bunch of voting rights groups there, and it's extraordinary the length to which the Republicans are going to keep people from registering to vote, throwing people off of the rolls constantly if they allegedly miss one election, relocating polling places, and so on. It's just old-fashioned voter suppression and disenfranchisement tactics. So apparently they're willing to roll the dice in taking some of the Republicans from 58 to 54 or something like that, because they believe that they'll be able to make it up in other ways. Right now, there are 38 members from Texas. There are 25 Republicans. There are 13 Democrats. It's already terribly gerrymandered. It's not like Republicans have a 2-to-1 advantage statewide in the popular vote. It's much closer than that. Then maybe the Republicans have 2 or 3 points, even with all the voter suppression tactics. But they have a 2-to-1 margin over us in the Texas U.S. House delegation. Well, they want to try to go to 3-to-1, right? They want to go to 30-8. And they want to use their same power to do that in Florida or Ohio. I mean, if they get away with that, the Democrats are going to have to fight back by using the leverage we've got in states with concurrent Democratic majorities in the state legislatures in order to do the same thing back in California or in New York or, who knows, in Maryland. They have created a fight fire with fire situation. And, all we can do is urge the Republicans to step back from moving from a decennial redistricting once every decade to gerrymandering whenever they think it can help them. I mean, it's just a very dangerous move for us, but they're trying to lock in the really thin majority that they've got right now forever. So a very dangerous situation. It's an all-hands-on-deck moment for people in the Democratic Party to try to stop this.
And as you'll recall so well, this began with a dark money-funded plot that went by the name Red Map. And the first election in which this gerrymander strategy was deployed, the Republicans controlled Congress by, I want to say, 30 seats in a general election in which the Democrats had received more votes across the country for Congress than the Republican Party had. So they lost the popular vote and won by 30 seats in the House head count because of that gerrymandering, and they've been living off of that ever since.
You know who learned a lot from that was Orban in Hungary, who has basically adopted MAGA Republican gerrymander tactics in his country. And he started out with a plurality, not even a majority support in the public there, but has been able to build super legislative majorities through gerrymander tactics. So this is not some peripheral issue in any way. This goes right to the heart of democracy. And, John Dewey said that the only solution to the ills of democracy is more democracy. And what we're suffering from today is not democracy. It's all the impediments and obstructions to democracy, like the voter suppression, the disenfranchisement, the gerrymandering of the districts, the corporate dark money you've done so much stuff on, Sheldon. And so lots of times when we're out there fighting, we say, well, we're defending democracy, which to me feels way too passive. We're certainly doing that. But democracy is not just this static collection of rules and practices. It is a project, and it's a process in motion. And we got a long way to go before we get to anything like real democracy. So we got to defend the democracy we have, but we got to keep going. And statehood is a great example of that. And I'm not talking about Denmark and Canada and Panama. I'm talking about statehood for Washington, D.C., the only capital city on earth that's disenfranchised in its own federal legislature. And we passed it twice in the House. I was proud to be the floor leader on that with Eleanor Holmes Norton. And when I got up, I thanked the 713,000 tax-paying draftable citizens of Washington, D.C., who had a valid, bona fide grievance against Congress and yet didn't come down and beat the daylights out of our police officers and storm the Capitol and injure and hospitalize 140 people. They petitioned for statehood the way 37 states have done in the past. And we need statehood for Puerto Rico, too. 3.5 million American citizens completely locked out of our legislative process. So we got to keep the wheels of democracy moving forward, or we're going to lapse into Orban-style authoritarianism in America.
To think that America used to export democracy, and now we're exporting anti-democratic method to international strongmen like Viktor Orban of Hungary.
Well, and we got to start importing some ideas from ourselves. For example, we need to get rid of the Electoral College, which is a relic and a remnant and an accident waiting to happen all the time. How about we elect the president the way we elect governors and representatives and senators? Whoever gets the most votes wins, right? As you say, we spend millions of dollars exporting American electoral democracy around the world. And the one thing they never come back to us with when they're writing a new constitution is, oh, you know that Electoral College thing you've got? That's a great idea. We'll go with that.
Let's do that. Well, we're going to be wrapping up shortly, but it would be a shame not to address President Trump's Jeffrey Epstein problem. Your body has actually been closed down because the speaker can't deal with his mutinous Republicans on the Jeffrey Epstein issue. The president has said that he wants the attorney general to release all credible evidence and all grand jury evidence. What is likely to come through those two sieves?
Yes. Well, first of all, the mutinous Republicans are the vast majority in terms of what they're thinking and what they've said. There are now, I believe, a dozen of them who are actually faithful to their statements, and they are going to sign on to a discharge petition, which is the means by which we get a bill that's stuck in the clause of leadership out of the leadership's hands and onto the floor. And so every Democrat will sign that and vote for the discharge petition. If we have a dozen Republicans, we've got enough. And the vast majority of the American people want to see that the Epstein files are released, like Donald Trump and Pam Bondi and Kash Patel have been demanding for months. And then suddenly they looked in there. Trump had more than 1,000 FBI agents working 24-hour shifts. These people were working, going through every document, every video, every photograph, and they were supposed to flag the ones that had Donald Trump in them. And what do you know? They come back and they say, no, under no circumstances do they want any of this going public. And I think they would probably just destroy the incriminating evidence, but they don't want to do that because too many people have seen it. At this point. So Trump is trying all of these diversionary tactics, as you say. He's saying, well, I want all the credible evidence to be released. Well, who's going to be the judge of that? What's credible? Pam Bondi, who has said she reports directly to Donald Trump. They're asking for the grand jury testimony in the Epstein and in the Maxwell prosecutions to be released. Well, the first thing to notice about that is that's not even necessarily relevant, or to put it differently, that's a very small part of the whole universe of relevant information. They've got the relevant information. All they have to do is release it. They don't have to go to court to ask for a release of these grand jury documents. I mean, that's an irrelevant distraction. Under Rule 6E, which you can explain far better than me, Sheldon, a lot of that is going to have to be redacted and eliminated in any way. But we don't have to get into that whole decoy. All they have to do is release the files as they promised to do. And, please say a word about Rule 6E, if you would.
Yeah, well, having put big cases into the grand jury, two things are very clearly true about that. One is that you only put a sliver of your entire case file into the grand jury. Your job is to go in, get the grand jury to determine that there is probable cause to pursue the criminal charge against the individual.
Against that person.
Against that person.
Not anybody else, even if there are other people out there.
Correct.
Yeah.
And so you narrowly focus your evidence on making that presentation, and it can be 2% of your case file. It could be 10% of your case file. In a super simple case, it might be half of your case file. But this is a complex matter that, as you said, had 1,000 FBI agents prowling through the documents.
More than 100,000 documents.
Yeah.
So what was wrong with Donald Trump's original idea, which is just release them? I mean, obviously redact the names of victims who were children at the time, but otherwise release them.
Yeah.
And let's let the chips fall where they may. That's what they were saying all of this time.
Yeah.
What has changed? Do they only want to go after the rich and powerful elite that is preying on children if they think it's Democrats? And now that they're coming to the recognition, belatedly, that Donald Trump is all over it, they don't want it to be released anymore? That doesn't speak very well for their convictions.
And to your question about 6E, that's the rule of court that says that if you're a witness in the grand jury, you can go outside the grand jury and say what you said. You're not under any kind of a gag order. But if you're the prosecutor, you don't get to talk about what happened in the grand jury. That is secret, and it's designed to protect against prosecutors using the grand jury to poison the jury pool or ruin people's reputations by taking evidence before they're even at the trial phase and getting that out into the press and into the community. So it has a very, very good basis. And the clever lawyers surrounding Trump know that, and they know that a great deal of the information that they claim to want to get out as grand jury information is not, in fact, going to get out. So, as you said,
it's going to be up to the judges.
This is a decoy.
Yeah.
And then they can blame the judges.
Right. And the judges, I can't remember exactly what the standard is, but it's something like there has to be special reason or special cause.
Yeah, it's very rare
to do that.
Well, Jamie, thank you very much for being with us. We have a huge battle ahead as we move towards next November and the prospect of being able to put the House in Democratic hands, put the Trump administration under real accountability of significant House investigations, and also, with any luck, flip the Senate as well. You're terrific to be here. I really admire your work, and thank you.
And thank you. It's a pleasure to work with you every single day, Senator Whitehouse.